There's no two ways about it. Legal design is effectively a term that people use that I find can be quite confusing, because what on earth does it mean? And it just reminds people of pretty contracts. I think that's not what it is. So design thinking is a very old methodology that has been used across the board in various industries, and it's effectively a method by which you create solutions to problems by really focusing in on the user's needs. So instead of so in the legal world, as a lawyer, you might say, I need to cover myself when I write this contract. So if anything happens, it's waterproof and no one can say that my drafting was terrible. Or they might say, I need to create this contract so that if the judge sees it, they'll be able to interpret it in this way. But by doing that, we're ignoring the main user of that product, because your contract is a product. And just to be really clear, design thinking in law doesn't only apply to contracts, it applies to everything that we do in not just the in-house space, but generally. And so it's important to focus on the predominant user so that you can create something that's fit for purpose. So in the use case of a contract, the end user is usually the business person. It's not even the lawyer in-house or externally that's drafting or reviewing or negotiating that contract. It's the business user, because that business user will need to interpret it, operationalize it potentially, and then work on a project or receive a service on the basis of that contract. What good is it if the business person can't understand it, or sort of understands it, but needs support from a lawyer to interpret how it's going to work on the ground? You're not really creating something that's fit for purpose. Fit for purpose in law doesn't necessarily mean it's waterproof in case this goes to court. You know, so in the case of NDAs, less than 1% of them get litigated. In the world of law, less than 2% of disputes get litigated, because most of them get settled outside of the courts. So the persona of the judge is a very rare one that will ever see that thing that you've created. So you should be focusing on the needs of the user. And by focusing on the needs of the user, you need to get to know who the user is. So business person doesn't really want to read legalese, doesn't understand it. How does that person feel when you put a contract filled with legalese in front of them? Or if you ask them to follow a process that's fit for purpose for the legal team, but is really confusing for the business person, it's just not going to work. They're not going to engage, or they will engage, but begrudgingly. So there's a huge knock-on effect when it comes to that. So taking a step back, applying design thinking is just taking a very empathetic approach towards the user and using processes whereby you don't just jump to the solution, but you empathize with the user, you understand what they need, you do a discovery piece there, and then you put together some things that you think might be viable, you test them, you iterate, and then you create your solution. In law, that's not something that we're ever taught to do. We're taught perfection from the outset, and if you screw it up, you're screwed, because you're going to get sued and your reputation will be damaged. So taking that fail fast, fail quick, get it right through iteration approach is design thinking in law, and the output is an artifact that is fit for purpose for the end user and not for a scenario whereby it will go back into the legal system.